contract with B, and in the contract he has given the right to B that B may enter his forest and cut all kinds of plants and trees above the height of 10 feet, and that too for the period of 5 years. Now, what is the nature of right which is created in favor of B? Understood the illustration? हाँ जी, क्वेश्चन समझ आया? Students, have you understood the illustration?
Yes, ma'am.
हाँ, तो बताओ फिर आंसर बताओ. There is a person A, he has entered into contract with B, given the right to B that he may enter his forest and he can cut all kinds of plants and trees above the height of 10 feet for a period of 5 years. So the right is spread over the period of 5 years, and the right is to cut all kinds of plants and trees which has reached the height of 10 years or 10 feet or above. So what kind of a right is created in favor of B? Is it a right in immovable property or is it a right in movable property? Hanji, think about.
Ma'am, I think it is a right in movable property.
Okay. Any other answer? Hanji. Uh, okay, if you're not able to answer. First of thing, but you have to see that what kind of a right is created. उसके लिए आप क्या देखोगे कि what is the right? The right is to cut all kinds of plants and trees and not only timber trees. पहली चीज. So your first condition is not fulfilled here. Even if some of the trees would have fallen within the category of timber tree, if they would have fallen within the category of timber tree, then we'll see whether they have reached a particular stage of maturity where it is used as a wood. Now it has reached the height of 10 feet and above. So we can say that yes, it has reached the maturity level. But then we'll see what is the intention. It is whether it is intended to be cut reasonably early. So for this, you see that the right, it is spread over the period of 5 years, and 5 years is a long time. It is not reasonably early that the trees can be cut. So the thing is that the trees, they are left to take further benefit, from earth for its sustenance. They are drawing nourishment from the land for its sustenance. Because of this reason, this is a right which is created in immovable property and not movable property. One more example. For example, in this case only, the right which was granted is to cut only standing timber for the period of 6 months. Now, what is the right? Is the right created in favor in nature of immovable property or movable property?
Movable
Ma'am,
property.
now it is in movable property.
Yes, now it is in movable property. For the reason, pehla hai standing timber, and second is has to be cut within the period of 6 months. So 6 months is a reasonably early period when we talk about trees. So this is a right which is created in movable property. Another illustration. Now, say there is in this case only, the right is granted to cut only timber trees for the period of 10 years. And all the trees in the forest, they are fully grown and mature trees. What is the right? All the trees in the forest, all the trees in the forest, they are fully grown they are mature trees, means they can be used as the timber. The right which is granted is to cut only timber trees for the period of 10 years. So is it movable or immovable?
Ma'am, immovable.
It is going to be immovable because the intention is not to cut them within a short period of time, but the right it is spread over period of 10 years. So because of this thing, because of this reason, this condition is not fulfilled and the right which is created is a right in immovable property. We have a landmark case on this point, Shantabai versus State of Bombay. 1958 का सुप्रीम कोर्ट का जजमेंट है ये. In this case, there was a person A who was owner of a forest, and he executed an unregistered document which was styled as a lease. So he executed an unregistered lease document in favor of his wife. The consideration was 26,000 and the time period was 12 and a half years. And as per the deed, he has given her the right to enter into the forest and cut bamboo, fuel wood, and teak tree, with a restriction that she cannot cut the teak plants if they are under the height of 1.5 feet. If the teak trees they reach that height or above it, then she was allowed to cut them, but within the period of 12.5 years. Now क्या हुआ? She enjoyed the rights for 2 years, but there was an act which was enacted, Madhya Pradesh Abolition of Proprietary Rights Act, and all the proprietorship in that forest it vested in the government. So there was a transfer of ownership from one person to government, and because of this reason, the government did not allow the wife to take and to cut more trees from the forest. Though she applied for compensation, etc., etc., sometime for some period she was allowed, but later she was refused entry in the forest. She was stopped by the forest officer. So she filed a petition in the court under Article 32 of the Constitution, and she contended that the right which was created in her favor, it was a right in movable property, and because she was not allowed to allowed to uh, uh, cut the trees and take the trees out of the forest, then she is entitled to compensation. Now, question before the court was that what was the nature of right which was created in her favor? Is it a right in movable property or immovable property? Why this question is relevant to be answered? Pehli cheez, if the right which was created in her favor, if it is a right in movable property, तो mere possession of property, delivery of possession of property with the intention to transfer of title, it is enough. कोई दिक्कत की बात नहीं है फिर. So if there is a change of ownership, she is simply entitled to compensation, isn't it? But if it is a right in immovable property, अगर immovable property की बात कर रहे हो आप, so there is a requirement for transfer of immovable property. There is a process. We discussed this process. There has to be a document, a written document. It must be executed, attested, and registered. So this is a procedure through which you can transfer a valid title, through which you can transfer a property, immovable property. Now, if the right which is created in her favor, it was a right in immovable property, then the right was transferred through an unregistered deed, unregistered document. It means no right is created. So that was the reason he tried to prove that the right which was created in her favor, it was a right in movable property and not immovable property. क्योंकि अगर immovable property की बात होती तो रजिस्टर्ड डॉक्यूमेंट के थ्रू होना चाहिए था, बट इट वाज नॉट द केस. अगर आपका चेंज ऑफ ओनरशिप होएगा तो शी वुड हैव द राइट टू क्लेम कंपनसेशन. मूवेबल प्रॉपर्टी में भी अगर चेंज ऑफ ओनरशिप हुआ है तो शी इज एंटाइटल्ड टू कंपनसेशन. That is the reason she tried to prove that the right which was created was the right in movable property and not immovable property. Now, the court held that first of all, there was a right to enter upon the land of another and to take benefits arising out of the land. So, it is a right which is a right in immovable property. And court held that the right which is created in the favor of wife, it was a right in immovable property because it was spread over a period of 12 years. तो intention क्या है यहाँ पे? Intention is not to cut the trees at reasonably early period of time. And because it was a right in immovable property, the same could have been created only with the help of a registered lease deed and not unregistered. And in this case, the right was created with the help of an unregistered lease deed. Because of this reason, the wife cannot be granted any remedy. This is what the court observed. Court observed that the duration of the grant is 12 years. It is evident that trees that will be fit for cutting 12 years hence will not be fit for felling now. Therefore, it is not a mere sale of trees as wood. It is more. It is not just a right to cut trees, but also to derive a profit from the soil itself in the shape of nourishment in the soil that goes into the tree and make it grow till it is of size and age fit for felling as timber, and if already of size, in order to enable it to continue to live till petitioner choose to fell it. So because of this reason, that there is to derive a profit from soil itself in the shape of nourishment from the soil and to let it grow till the age and size for which it is capable of being felled as a timber. Because of this reason and this reason, we cannot say that the right which is created in favor is in movable property, but it is a right created in immovable property. Understood? Any confusion? Yes, students? भाई हाँ ना का जवाब दे दो.
Yes, ma'am.
बच्चों अगर समझ में नहीं आ रहा है तो मुझे बता दो, अगर सुन नहीं रहे हो तो बात अलग है. देखो
Ma'am,
Ma'am, can you the importance of right in immovable property?
बेटा फिर से एक बार पूछना.
मैम जैसे दोनों राइट्स में एक बार डिफरेंस बता दो.
बेटा मूवेबल प्रॉपर्टी के अंदर जब आप राइट क्रिएट करने की बात करते हो, इट कैन बी बाय पासिंग ऑफ डिलीवरी, इट कैन बी बाय डिलीवरी ऑफ पोजेशन ऑफ प्रॉपर्टी. जैसे मोबाइल फोन है, इट इज मूवेबल प्रॉपर्टी. मैंने सिंपली आपको दे दिया है, यू आर नाउ द ओनर ऑफ द प्रॉपर्टी. ठीक है, आपने मुझे 10,000 दे दिए, मैंने आपको मोबाइल फोन दे दिया, नाउ यू आर द ओनर ऑफ द प्रॉपर्टी. बट इफ आई हैव टू गिव माई हाउस टू यू, इफ आई हैव टू सेल माई हाउस टू यू, आपने भले ही मुझे पैसे दे दिए और भले ही आपने पोजेशन ले लिया प्रॉपर्टी का, स्टिल द ओनरशिप इज नॉट ट्रांसफर्ड. व्हाई? देयर इज अ प्रोसेस, देयर इज अ प्रोसीजर एस्टैब्लिश्ड बाय लॉ by which you can transfer a valid ownership or valid title in immovable property. जैसे आपका लैंड अगर आपको अपने नाम करवाना है तो रजिस्टर्ड डीड के थ्रू ही होना चाहिए ना. वो अगर वो रजिस्टर्ड डीड के थ्रू नहीं हुआ है, then no right is created in your favor. अगर मैंने सिर्फ आपको लैंड का पोजेशन दिया है, ठीक है, आपने फॉर एग्जांपल मुझे 50 लाख रुपए दे दिए सुकृति, एंड आई हैव गिवन द पोजेशन ऑफ लैंड टू यू, बट आई हैव नॉट एग्जीक्यूटेड अ रजिस्टर्ड डीड इन योर फेवर. एंड ओनरशिप, नाउअडेज ओनरशिप ऑफ प्रॉपर्टी, इट इज अ पब्लिक अफेयर. आप जब किसी प्रॉपर्टी के आप ओनर हो, इट इज देयर विद द रजिस्ट्रार. आपके पब्लिक डॉक्यूमेंट होते हैं ओनरशिप के डॉक्यूमेंट्स, टाइटल डीड जो होती है. सो इट इज देयर इन द रजिस्टर ऑफ द रजिस्ट्रार. वहां पर अभी मेरा नाम ही चल रहा है ओनरशिप में. आई एम द ओनर ऑफ द प्रॉपर्टी. सो फॉर वैलिड ट्रांसफर of immovable property, what is required that it must be with the help of a registered document. लेकिन मूवेबल प्रॉपर्टी की अगर आप बात करो, कोई रजिस्टर्ड डॉक्यूमेंट की जरूरत नहीं है, सिंपली आप ट्रांसफर कर दो पोजेशन, वही काफी है. दैट इज कंसिडर्ड टू बी अ वैलिड ट्रांसफर ऑफ टाइटल ऑफ मूवेबल प्रॉपर्टी. इमूवेबल में ऐसा नहीं होता. और अगर रजिस्टर्ड डीड नहीं की है ना इमूवेबल प्रॉपर्टी में, यू डोंट हैव अ राइट इन द आईज ऑफ लॉ. आपका कोई राइट ही नहीं है, आपका कोई टाइटल ही नहीं है. Even though you have parted with 50 lakh rupees from your pocket, even though you are in possession of the land, still you do not have any right. Understood, Sukriti? So for defining the rights,
Yes, ma'am, understood.
for defining the rights of the parties, it is a necessity that procedure must be followed. और इस केस में क्या हुआ था? Procedure was not followed. It was a right in immovable property, लेकिन उसने unregistered deed के थ्रू ट्रांसफर किया था, कोई राइट ही नहीं क्रिएट हुआ, तो इसलिए नो राइट वाज देयर. ठीक है स्टूडेंट्स, आई होप टिल दिस पॉइंट अंडरस्टूड.
Yes, ma'am.
ऑलराइट, सो नेक्स्ट वी हैव इज ग्रोइंग क्रॉप्स. Growing crops are just like the timber trees, and it refers to all the vegetable growths that are in existence and practically have no existence apart from their produce. So if a growing crop is will be a crop which is in the existence and which may be in the process of or coming to fruition. Now it is only being in existence, it is of no use until and unless it can give you some kind of a produce. जैसे आप क्रॉप्स आप देखते हो, बहुत सारी क्रॉप्स हैं आपकी. नाउ टिल द टाइम it is not capable or it is not giving you any produce, till that time it is immovable property, just like timber trees we are talking about. So a transfer of a right to rear and pluck or take away fruit from trees, it relates to sale of growing crops, hence movable property. On the other hand, if the right is to sow, cultivate and harvest the crop, then in that case it is a right in immovable property. क्योंकि सो करना, देन कल्टीवेट करना, उसको हार्वेस्ट करना, इट टेक्स टाइम, पहली चीज. और ग्रोइंग क्रॉप्स और क्रॉप्स की का लाइफ स्पैन इतना नहीं होता, इट इज मेरली अ सीजनल थिंग. सो फॉर एग्जाम्पल, इफ आई हैव गिवन माई लैंड फॉर से, मैंने मान लो 5 साल के लिए अपना लैंड दिया है, इट वॉज फॉर द पर्पस ऑफ कल्टीवेशन. ठीक है, इट इज अ राइट विच इज क्रिएटेड इन इमूवेबल प्रॉपर्टी, पर पर्पस क्या है उसके अंदर? टू सो, कल्टीवेट एंड हार्वेस्ट क्रॉप्स ओनली, but still it will be considered as a right in immovable property because the time period is 5 years. The right is spread over the period of 5 years. लेकिन simply अगर आपका ये है, for example there is an apple orchard, उस apple orchard में there are trees which have come to maturity, there may be trees which have not come to maturity, but the right is to simply pluck the fruit and sell it in the market. What kind of a right is created? What is the nature of right? Pluck and sell.
Movable.
It is movable. पहली चीज आपकी मूवेबल की डेफिनेशन में भी बताया हुई है ये चीज, that the fruits and the juices in trees they are considered to be movable property. तो अगर फॉर एग्जाम्पल मेरा एक एप्पल ऑर्चर्ड है, उसमें ऑलरेडी एप्पल्स आर देयर, और मैंने बोला कि विद इन 10 days यू हैव टू प्लक द एप्पल एंड यू हैव टू सेल देम इन द मार्केट, सो दिस इज अ राइट इन मूवेबल प्रॉपर्टी. बट if I have given, Sukriti say, if I have given a right to you that for 5 years I am giving my orchard to you, whatsoever apple comes or is fruited upon the tree, you pluck it and you sell it in the market. Is it a right created in immovable property or movable property?
Ma'am, because of 5 years, it may be movable property.
Yes, it is immovable property because you are letting it take nourishment, you are letting it cultivate, you are letting it to grow. तो जब तक वो grow नहीं होएगा तब तक you cannot take it and you cannot sell it. So what is necessary that you are letting it grow. Similarly, grass, though grass is it is rooted in earth, but we have put it in the definition of movable property. It is movable property, but only when the intention is to cut it within a short period of time. Within a short period of time. If I have say if I have given a right to be to enter my land and cut grass for the period of 5 years, this is a right which is created in immovable property and not movable property, because here B is going to take benefit of my land. अब ग्रास है आपकी, अब ऐसा तो नहीं है जो ऑलरेडी राइव्ड है उसको तो चलो मैं ही इज गोइंग टू कट इट, बट द वन विच इज नॉट yet in existence, because of that reason the nature is that the right is in the immovable property. Oh, yes, students. So, even in the case of growing crops as well as grass, what we say that it is, though it is rooted in earth, but we have to see the intention of parties. What is the intention of parties? So, if it is to be cut reasonably early, then we say that it is a right in movable property. If not, then it is a right in immovable property. Understood? Any confusion?
Understood, ma'am.
Okay. Next we have is things embedded to earth. Now we have seen things rooted in earth. Now there is things embedded in earth. Embedded का क्या मतलब है इसके अंदर? Means it is by unnatural means something is put in earth. तो वो आपका embedded हुआ. Or maybe because of the reason of weight of a thing, it is going down in earth, वो embedded है. So what is the nature of those things which are embedded in earth? Will it be movable property or will it be immovable property? Now, just taken for example, there are bricks. The bricks, for the sake of convenience, they are put on the top of each other, but they are lying on earth. वो earth में ही है, because of the weight. जो bricks है वो आपकी थोड़ी सी जमीन में चली गई है. What is the nature? Will the bricks become part of the earth or will they remain to be movable property? Hanji?
Ma'am, they should be movable.
They should be movable property because it is merely because of their weight that they have gone down to in earth.
Yes,
Is it
ma'am.
because of this reason and they can be severed easily?
Yes, ma'am.
Because of this reason we are saying that they are the things which are not embedded in earth. They are merely movable property. और कोई आपका इसमें just a minute. Yes, students. So the question here is this, कि हम बोलते तो हैं that certain things they are attached to earth, some certain things they are embedded to earth, but what kind of an attachment is required for making a movable property as immovable property, or we say fixture? See, there may be various circumstances wherein a movable property, that is a chattel. It becomes a fixture, that is an immovable property. So for that we have to understand the doctrine of fixtures, जो कि आपका English law का doctrine है. It will be able to understand the ownership issues of the attachment or the things which are embedded in it. The first is quick quit, plantator, solo credit. It means that whatever is planted in earth, it becomes part of earth. And whosoever owns that piece of earth will own the things planted. It is an easy thing, like rooted in earth or planted in earth. For example, you have planted a plant. So मैंने अपनी प्रॉपर्टी के ऊपर अगर उस प्लांट को लगाया है तो इट इज कंसीडर्ड दैट आई एम द ओनर ऑफ द प्लांट आल्सो. Another is quick quit, inedificator, solo credit. It means whatsoever is built into or embedded into or attached to soil, it becomes part of the earth. And whoever is the owner of the piece of land will also become the owner of the thing attached or built or embedded. ठीक है, वेरी इजी डॉक्ट्रिन्स, नो कंफ्यूजन एट ऑल, कि कुछ भी अगर प्लांट होगा अर्थ में तो अर्थ जिसकी ओनरशिप में है दैट पर्सन इज आल्सो ओनर ऑफ द प्लांटेड थिंग. इफ एनीथिंग इज बिल्ट, जैसे कि लैंड हो गया, बिल्डिंग हो गई. इफ एनीथिंग इज एम्बेडेड, फॉर एग्जांपल यू हैव एम्बेडेड सम आयरन रॉड्स इन द अर्थ, और इफ एनीथिंग इज अटैच्ड टू द सॉइल, अगेन कोई प्लांट मशीनरी आपने अर्थ में या सॉइल में अटैच किया हुआ है उसको, सो इट बिकम्स पार्ट ऑफ अर्थ. एंड कंसिक्वेंटली जो भी ओनर है उस अर्थ का, उस पार्ट का, the person is going to be owner of the thing which is attached, which is built or which is embedded. Understood? The exception is to these doctrine is that there may be a contract to the contrary. If there is a contract to the contrary, then in that case the contract is going to be applicable and not the doctrine. For example, मान लो एक मेरा प्रॉपर्टी है, उस प्रॉपर्टी के ऊपर आई हैव इंस्टॉल्ड अ पंप एंड अ मशीनरी टू ड्रॉ वाटर. इट इज फिक्स्ड इन अर्थ. ठीक है, आपका हमने देखा होगा ना, वाटर पंप आप इंस्टॉल करते हो जमीन में. सो आई हैव टेकन, there is a contract between the party that the ownership of the pump, it will remain to be with me even though I am transferring the property in favor of B. लेकिन कॉन्ट्रैक्ट मैंने क्या किया है कि मेरे फेवर में ही रहेगा, मतलब ओनरशिप मेरी रहेगी पंप की. So in that case the doctrine will not be applicable, it is the contract which will be applicable. Second would be that whether the fixtures they are trade fixtures. जैसे एक बैंक है, बैंकिंग बिजनेस के लिए मान लो मैंने अपने घर का ग्राउंड फ्लोर आई हैव गिवन इट फॉर बैंकिंग पर्पस, सो दे हैव टू मेक कैबिन्स, they have to make lockers, and for the lockers they have to install the gates in order to protect the lockers. So the gates they are embedded in earth, the cabins they are embedded in earth. So because of this reason I should be the owner of those iron gates and I should be the owner of those cabins, but no, because if there is no contract to the contrary, the ownership of those cabins and iron gates would be with the person who is doing the banking business. ठीक है, क्योंकि it is necessary for the banking business to have these utilities. So they are considered to be trade fixtures which are fixed by the tenant, which are fixed by the person who is carrying on the banking business. तो इसलिए it is one of the exemption कि though the land, the property is mine, but because of the nature of business, the fixtures are trade fixtures, so they are owned by tenant. इंडिया में ये रूल थोड़ा मॉडिफाइड रूल है. We apply this rule but with modification. Modification क्या है? We have two rules in this. And these rules they are applicable only when the person was in lawful occupation of the property and not the trespassers. So the first rule is that the person is entitled to remove the attachment if he vacates the premises provided he must leave the land in the same state as it was previous to the attachment. कि आप अटैचमेंट को ठीक है मान लिया कि मेरा नहीं है, द पर्सन हु इज द ओनर ऑफ द लैंड, जैसे मैं हूँ, आई एम द ओनर ऑफ अ हाउस, पर उसके अंदर किसी तरीके का अटैचमेंट मेरे टेनेंट ने किया है. सो द रूल इज दिस, द tenant is entitled to remove the attachment provided he leaves my land in the same state as it was previous to the attachment. The second rule is that if he if he is allowing the attachment or improvement to remain with me and I am drawing any kind of a benefit from it, then I have to compensate him for the value of attachment. I have to compensate him for the value of attachment or the improvement. Understood? So, the things which are embedded to earth, whether they are part of movable property or immovable property, the question can be answered that who is the owner of the land. If I am the owner of the land, things which are attached, then we'll say that who has attached the attachments. If it is the tenant, then tenant should be the owner of the attachment. But if I have attached the attachment, I should be the owner of the attachment. So we'll see, there are various things which we have to see to answer this question, whether the chattel it has become a fixture or not. Now question is, what is the sufficient attachment which will convert the character of a thing to make it a fixture? कि किस तरीके की अटैचमेंट होना जरूरी है. तभी तो मैंने बोला, फॉर एग्जाम्पल द bricks which are lying upon each other just for the sake of convenience and now they are embedded to earth, whether those bricks have they changed their characteristics from chattel to immovable property? The answer was no. क्योंकि इंटेंशन क्या है आपका? इंटेंशन ये है that you are going to use those bricks for other purposes. This is the intention. And second thing was there that there was no sufficient attachment. Sufficient attachment आपका कब होगा? Sufficient attachment is going to be there when you are going to use cement, and then you are keeping one brick over the other with the help of the cement. So you are attaching it. This is sufficient attachment. Getting my point? So what is the sufficient attachment? What is the things which we can say it is embedded in earth? For example, एक आपकी building बनी है, उस building को बनाने के लिए you need to have a foundation. उस foundation के लिए you have to use that cement, you have to use brick, you have to use mortar. Everything is required to be used. Now, because of the use of cement, bricks, etc., the construction material, the foundation is now embedded in earth. So it is a sufficient attachment. तब हम उसको बोलेंगे yes it is embedded in earth and now it is part of earth. One thing. लेकिन bricks को सिर्फ आपने convenience sake के लिए एक के ऊपर एक रखा है. It is not sufficient attachment. पहली चीज, you can remove it easily, and secondly it was not intended to be used just like this. Getting my point? So embedded in, attached to, we have to see the sufficient attachment for this. कि sufficient attachment किस चीज में और कब है. अगर sufficient attachment है आपकी, so what is that sufficient attachment? किसको आप बोलोगे कि sufficiently attached है? For example, आप अपने घर में देखो, just if you are sitting in a room, just see, your doors are there. Can we say that doors, they are sufficiently attached to the room? हाँ जी.
Yes,
But
ma'am.
are they sufficiently attached? Can they be easily removed?
No, ma'am.
Yes,
But you
ma'am.
can simply remove the nuts and you can remove them.
Ma'am, they're removable.
Removable? Easily removable?
Yes, ma'am.
I'm not easily removable.
Not easily removable. Okay. Then what about the fan? Ceiling fan. Is it easily removable?
Ma'am,
Yes,
easily
ma'am.
is very vague and subjective. What is the definition of easy?
easy is that you are not destroying the things which to which the same is attached.
Okay. Yes, ma'am. Then easily removable.
Easily removable. Okay. आप लोगों को यू मस्ट बी अवेयर कि जो डोर जिससे लगता है उसको चौखट बोलते हैं, अगर पता हो आप लोगों को.
मैम चौखट तो उस फ्रेम को बोलते हैं, वो जिससे अटैच होता है उसको
Yes,
कप
yes,
बोलते
yes, yes, yes. That is the frame I'm talking about. So is the frame, is it easily attachable?
हैं. मैम फ्रेम इज द पार्ट ऑफ दैट रूम ओनली, नो रूम के अंदर ही तो फिटिंग की जाती है.
हाँ हाँ, अरे देख सुनो.
Ma'am, it is not easily removable.
यस मैम,
It
नॉट
is,
इजीली रिमूवेबल इन सपोर्ट.
हाँ, it is actually the frame. It is actually the wooden door frame to which the door is attached. है ना? So उसको हटाने के लिए, डोर तो आपका नट से आराम से हट जाएगा. देर इज नो डैमेज टू द रूम. लेकिन अगर आप उस फ्रेम को हटाने की बात करोगे, to remove it, you have to damage the walls. You have to damage the walls. So what is the sufficient attachment? Sufficient attachment is that of a frame. कि अगर आपने उसको हटा दिया ना, the walls are going to be destroyed along with the attachment itself. मान लो अगर आपकी वुडन फ्रेम है, वुडन फ्रेम को अगर आप हटाने लगोगे, इट इज वेरी डिफिकल्ट टू रिमूव इट विदाउट ब्रेकिंग इट, विदाउट डैमेजिंग इट. और उसको जब आप हटा रहे होंगे ना, उसके साथ साथ आपकी थोड़ा थोड़ा वॉल्स भी डिस्ट्रॉयड होंगी, क्योंकि वॉल्स में वो अटैच होते हैं फ्रेम. ओनली देन इट इज गेट अ फुल सपोर्ट. So door is easily removable, but the door frame is not easily removable. So what would say the sufficient attachment for us in this case would be for that door frame and not the door. अच्छा, एक और चीज मान के चलो. For example, आपका घर है and you want to sell it to someone. The person has come, he has inspected everything. At the time of inspection, there were the gates, there were the windows, everything were there. ठीक है, आपकी इलेक्ट्रिक फिटिंग्स भी थी वहां पे, सब कुछ था. नाउ आफ्टर द कॉन्ट्रैक्ट इज कंक्लूडेड, जो भी फिक्सचर्स है दैट विल pass to the person to whom you are selling your house, right? Are you empowered to remove the doors? Can you remove the doors? Can you remove the windows? Can you remove the ceiling fan?
Ma'am, if there is a contract like that, we can.
बिल्कुल, ऑफ कोर्स द कॉन्ट्रैक्ट, इफ देयर इज अ कॉन्ट्रैक्ट, ऑफ कोर्स यू कैन डू सो. मैंने वही बोला, तभी मैंने वो जब ये डॉक्ट्रिन्स आपको करवाए हैं तो आई हैव गिवन यू दिस एक्सेप्शन. If there is a contract to the contrary, then you can do so. But I am simply talking about there is no contract like this. I've stated the fixtures they will pass to the transferee. The fixtures.
Ma'am, then it cannot be removed.
Then it cannot be removed. The doors, the windows, it would be considered as fixtures. The ceiling fan, though, it can be considered as chattel. आप करते हो ना, मान लो कोई एक टेनेंट है, टेनेंट अगर आता है अपना तो फैन लगाता है, समटाइम्स ही ऑल्सो वो लाइट बल्ब भी लगाता है, दैट ही डज. ठीक है, एंड व्हेन ही लीव्स ही विल रिमूव हिज फैन, ही विल रिमूव द लाइट बल्ब्स एंड ही टेक्स इट अवे. तो वहां पर क्या है, दे विल रिमेन टू बी अ चैटल and not immovable property and not fixture. On the other hand, if it was installed by the owner, of house, जैसे हमने अपने घर में सीलिंग फैन लगाया हुआ है, so what is the purpose? The purpose is to use this room and for beneficial enjoyment of this room आपने लाइट लगाई हुई है, आपने फैन लगाया हुआ है, और उस फैन को चलाने के लिए, लाइट को चलाने के लिए देयर आर इलेक्ट्रिक वायरिंग्स, इलेक्ट्रिक फिटिंग्स है. So that electric fittings, they are part of your land, they are part of your building. Getting my point? So what is embedded to earth and attached to what is embedded to earth, उसके लिए we apply these doctrines. Understood?
Yes.
क्वेश्चन आपका हमेशा यही रहेगा, व्हाट इज दैट सफिशिएंट अटैचमेंट through which you can say that now the character of a thing is changed from a chattel to a fixture. This will always remain to be a question, or it has to be dependent, it has to be answered for every case, because it is a mixed question of law and fact. It is a mixed question of law and fact. You are going to apply these laws, ठीक है, and then you have to apply the facts कि क्या sufficient attachment है इस particular case में. So the question whether any attachment which is embedded in the earth or permanently attached to anything which is attached to earth, whether it is immovable or movable, it is a mixed question of law and fact, would be depending upon facts and circumstances of each case. ठीक है, इसके जो rules है we are going to study in the next class. नेक्स्ट क्लास हमारी कब है? कल तो नहीं है, हाँ, वी हैव इट ऑन थर्सडे. चलो ठीक है, विल स्टडी इट ऑन थर्सडे. ठीक है बच्चों, इतना समझ में आया ना आप लोगों को? आई होप आई एम हेल्पिंग यू क्लियर योर डाउट्स एंड यू आर अंडरस्टैंडिंग द कंसेप्ट्स.
Yes, ma'am.
Yes, ma'am.
चलो ठीक है. Attendance. I'll mark your attendance. I have downloaded it. I've downloaded your attendance. ठीक है. Thank you so much.
Thank you.
Have a nice.
Thank you, ma'am. Thank you, ma'am.
Thank you, ma'am.
Thank you, ma'am.